Okay, all right, on to part two of our family law primer. And what we're going to talk about now is the case procedure. So let's assume that the client has now retained. So now it's time for the next step. And of course, for us, the next step in a client journey is going to be the case manager follow-up meeting. This is vital in family law because every family law client is going to need communication, and they're going to need communication occasionally fast. All of them are. Some of them are going to demand it a lot, and some of them, we have to chase down a little bit. But one way or the other, communication is going to be important. And let me just clarify to everybody that's a family lawyer, you will not have time to be able to communicate with your clients. Okay, and I'm going to say something a little bit controversial, and the state bar is not going to like to hear this, but let me make it sure that you understand. I advise you to not call back your clients. And I know that sounds terrible, because I remember when I first heard that information when I was starting out, and I was like, not me. I'm going to be the one that's going to do this. I will never let a client go out. I'm going to call them all back, and I'm going to do this all the time. And that is admirable, and that is fantastic. And you will stress yourself out, and you will not like family law. I will just say this: if it's important enough, your client needs to make an appointment and come in, or do it by phone on your time. Because if you answer and respond every time your client has a question, you're going to point to and point through them to death, and they can't afford their trial later on. You're not hurting their case. You are responding appropriately. Now, here's what I would say. You should, I almost said shall, because shall is probably the right word, but you should have an open portal with the client, and that's going to be your way of communicating with them. And that way, everybody knows what's going on in your case all the time, even if you were to, get COVID tomorrow, or be out of, God forbid, be on a real vacation where you don't answer the phone or your emails. Whatever it's going to be, at some point, you're going to be unreachable. And because of that, you will learn one unreachable moment at a time. Maybe you're just in trial on another case, that by God, your clients seem to be okay without having an immediate access to you by phone. So the reason why I say that right now is because that's what the case manager meeting is for. That's where their relationship's going to be. The reason why we don't use the word paralegal is because I don't want people to think nurse is the doctor, as paralegal is the lawyer, where it's like, oh, well, they assist the doctor or whatever it is. No, they manage your case. They decide when it's time to talk to Caitlin. They decide when Haley's available to be able to talk to you. Now, at the same time, make your appointment schedule available, because sometimes the clients do need either actual face-to-face or that phone call back and forth about their case. But you do not need to be the one who's just picking up the phone and calling them back. All right. The case manager can do that. But that doesn't work unless the very first time that they're talking about their story is the case manager. So, you haven't taken a ton of notes, because that consult was about trying to get them to retain. Now the case manager needs to really dig into it. And the case manager meeting is one where they get to know the client. They're the ones who should be assigning the first pleadings. Now, you've been doing a little bit of this when you sit the consult and you were doing some of the drafting and the custom fields, that kind of stuff. But they're the ones that are putting it together to make that more complete. They're the ones who are doing the summons, the status of minor children affidavit, have clients sign. South Carolina cases, you must do a financial affidavit. So if you're in South Carolina, literally, for you guys in North Carolina do not know this, family courtrooms have a sign on the door that says do not come in without your financial affidavit. You're not even allowed to go into the family law courtroom without having that done. If you don't have one done, and you have to update it each time you go to court, because they want to know that the financial aspects are handled. They will hand you a blank paper and say, come back when you have this filled out. They will find out your witnesses, put all of those witnesses into KLO, prepare subpoenas if necessary, and collect homework from the client. By the way, is they're building this up, and I know that case managers might be listening to this on video at some point, but attorneys too, make sure everybody is a contact at the side of your own KLO. I mean, the opposing attorney, really the opposing party, so you have that information to its service. Any witnesses in the case, everything needs to be on the side. Why? Because most of your case, your work is going to be done right here on your cell phone. And I'm all the time on my KLO on my cell phone. And it is so awesome when your client sends you an email that says, hey, do you have such and such document? And literally while you're in court, you can just go to KLO, boom, 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 and send them a document immediately. And I had it happen last week. They're like, wow, that was fast. It was a client who was emailing me from a case that happened 3 years ago. She was getting a new bank loan and needed the separation agreement. Within 30 seconds, she had it in her hands. And I never touched a computer to do it. KLO is fantastic on that part of its app. It's taken a long time to get there. I will tell you, but we are there now. And I don't know about you guys, but I do most of my phone calls in the car. And when I need to call opposing counsel, I don't want to look it up. I want it to be there. I go to KLO, and it's, the little blue glowy number that I can just click and call them. Your experts need to be in there. We'll talk a lot about experts later on, because I don't want you to feel the burden of your cases. I want you to have other people feel the burden of your cases. But this case manager meeting is great. Now, let's be honest, not all of our case managers are the same. Caitlin can brag a little bit here. She's got Jeannie over there at that office who and Chloe too. Yeah, you're right. And that's a pretty good example of what's going on, of having somebody who's been doing it for, 20 years plus, and then having somebody who's new, but has been trained and doing a good job. Some of our case managers are new. That's just the nature of what we do. And some of them are strong in these areas, and some of them have some work to be done. Ultimately, we would like to be able to have practice area case managers that would just know family law, and they will be fantastic for us, and they will build that up. We're not quite there yet, because right now we need case managers keeping the offices open while the attorneys are traipsing around the world doing their crazy work. But as they become more and more specialist, I think that these case manager meetings will get better. But honestly, all they have to do is be an organized person. If they are organized and they can ask a simple question, this is what in case manager meeting, how I tell them to get to know the client. When did you meet? And then say, and then what happened? And if you can just ask that question enough times, you will somehow get to the chronology of what happened. And that's where I like for the facts to be. For all lawyers in here, you will know what I'm talking about what the facts need to look like out of a case manager meeting, because you've read any Court of Appeals decision or appellate court decision. The facts should look like the facts in appellate court decision. Pretty quick, to the point, the salient facts. There doesn't need to be a lot of and then he got a tattoo of another girl. Actually, that would be one. I think I'd probably put that one in there. But some of the things are not going to be necessarily salient facts in the case. But I don't mind them being extra facts, right? I just want to make sure that all of the ones that are important are there with dates, as best you can. Like, he left on this date. I need to know that. That one you don't need to have missing. But the case managers are not perfect on that. You want to make sure that they're getting a good job of it. And of course, I like the facts to be in third person, so your client's actual name is in those, because I think it not only does it look more professional, you can use that in briefs and that kind of stuff later on, which I advise you to do. Think of it as being like, this is going to be the facts section of all my briefs. It doesn't matter if my brief is just really only on a drug test. I still want all my facts in that brief, because you got, good advocacy says every time put the facts. Court of Appeals doesn't. They put every fact in their facts area, even if it's not salient to what the decision is. They want all the facts to be in there. Why? Because it helps another case later on be able to say, okay, here's kind of what's going on or what's happening. For you, it just makes you keep telling the story. You want your story to get it right, and you keep telling your client's story over and over. Doesn't matter if that's a DSS case, a custody case, whatever kind of case that you're dealing with, you want the facts to be there and you want to constantly be updated. So that's what the case manager meeting is. As soon as the case manager meeting, and remember, like I said earlier, that case manager meeting might be happening the same day. It's great if it can happen the same day they retain. Don't think you have to schedule it out or something like that. Then as an attorney, you start working on option 2, which is an opinion letter trial brief. And it's very simple. An opinion letter and trial brief are the flip sides of the same coin, right? You want your opinion letter to be the first time the client gets the real information of what's going on. Up to this point, remember, we've built trust. We've done a lot of back and forth, but the client really hasn't been told how bad their case is. And sometimes they take your friendship, your familiarity with the facts as being somehow an approval of the result. And we do it too. The judge is like, oh, the judge was listening really well, and the judge really recited the facts back, and we think, oh, the judge is on our side. And then we're shocked when they're not. Well, I think the same thing happens to our clients. They hear us say like, oh, you're a good person. Oh, it's great that you got out of that relationship and all these other things. And they're hearing you say, man, I'm glad you kind of escaped that domestic violence situation. They're hearing you're going to get full custody of your children. And it's difficult because you have to be able to say that. Now you need to hear the facts of what's going on. Well, the opinion letter is the right and proper place for that. Now, first of all, opinion letters don't have to be actual letters, right? I mean, chances are it's just going to be dumped right into their portal. Maybe emailed to them. I like the portal. It's more secure anyway. An opinion letter is not the kind of thing you want floating into the wrong hands. It's the clients. They can give it to whoever they want to. If it's in the portal, they can give access to whoever they want to. But we know that it doesn't mistakenly get to the wrong place, because the opinion letter should be telling them things that we really wouldn't want the other side to hear, because it's going to be the facts again. And what's really good, important about about the opinion letter facts, you're going to put in there, please correct any of these things. So later on in trial, when you get surprised, you're going to say, on day 3, I sent you an opinion letter that had all these facts and you did not correct it. If you don't correct it, all of my opinions are based on these facts. So I think it's really important for you to be able to say, like, correct those facts. And that needs to be in that opening paragraph of saying, like, these are the facts as I understand it, and we'll be arguing, and the later opinion is based on the facts as they are. So, if you get a different one, you truly can look at your client and say, if I would have known that, I would have advised you completely differently, going into this. And here's where it is. So, and it's kind of like the truth, the whole truth, and nothing but the truth. Like, it's not like, don't just correct the facts that are in here, add in the things that are important that you did not tell me, especially the bad stuff. So, so the first part is make sure you have that. Second part is you want to put the law in. And, in that, I've got in the opinion letter a few family law stuff. I think I just have like a breakdown of custody in there. I have some of these things. That may need to be updated. I'd love to see that be constantly updated as to those things. But our major stuff needs to be in there. Remember, they don't know that custody is best interest of the child. They don't know that there's 5 factors that case law has talked about. The educational background of, the psychological, the emotional, all of the things that courts say, hey, spiritual in North Carolina. I mean, things that are, all of these factors, they may not know that all these things are important. They'll be like, well, the judge has to give me custody. I've got the better school. Well, you're right. Education is one of the factors, one of 5 factors that the courts do not say one is more important than the other. They would rather a child be in a loving home and a bad school than a fantastic school and not loving home. So, these are the kind of things that it's good to put into an opinion letter and be able to factor that. And I do think it can just be raw law. there. You don't have to, it doesn't have to be necessarily eloquent where, it's an A+ or a bar exam perfect on this stuff. It can just be like, here's the law in custody, boom, lay it out there. They're probably not going to read this section very much. It does kind of help you elevate who you are. And most importantly, it's a little CYA, because it's going to say things in there like, hey, the law is that for instance, testimony of the child. I think I put that in there. People think, well, my child can't testify, or my child can testify, or the child can testify when they're 12. They've got a lot of different ideas in that. You just hit them up with what the law is in this. You just say, like, well, Hinkle case says it's appropriate. The judge gets to determine whether it's appropriate and what weight to put on a child's testimony. But that's in there. You've given it to the client. There is no way there's any kind of issues that they could ever talk about your representation if we have a well-written opinion letter. And this is a chance for you to just be a lawyer. I mean, you don't have to go out of your way. This is the kind of stuff that you're good at from law school, and why it's like, oh, law school didn't teach me everything. Didn't teach me how to do a subpoena or to do a civil summons, or what maybe they told me how much time I had to do these things, but I didn't remember that. That wasn't in my notes. Okay, that's fine. But you know what? Those things are actually kind of small. Writing a good opinion letter, they did train you for that. They did train you saying, like, okay, this is your memorandums, your stuff like that. And it should have the worst case scenario, because the conclusion needs to be pretty clear, and you want to set that bar low. This is not a time for you to play Superman, or, to be like, I'm going to ninja stealth them and get you full custody, or whatever it's going to be. This is not that opportunity. You have a chance to be able to do that later, but at this point, it needs to be like, look, despite all of the facts in this case, Buncombe County is likely to do a 50-50 arrangement. That is 80% of all cases in Buncombe are going to end that way. And of the 20%, most of those are uncontested in the other side. So understand the chances of you getting something besides 50-50 very low in this scenario. We need to protect your child in another way. Whatever, these are the kind of things that makes a really good opinion letter. Spartanburg County is most likely going to use their format for custody. And that means one side's going to get custody and the other side's going to get some kind of large visitation schedule. That's fine. Just make sure that you've advised your client as to those things. And they may not love it, but I'd rather them have that fight on an opinion letter than after the result of a case, right? And if it's written well, I mean, I have never seen another attorney be like, oh, that was a waste of time. I mean, in fact, most attorneys out there, when they see our opinion letters in family law cases, are super jealous. And they go, oh gosh, that's a great idea. But nobody does it in family law. We do it every time. And I think it's a huge difference. Now, it does mean that your client's not going to be rosy-eyed going through the rest of the case. And sometimes the other attorneys are like, well, they're fighting for their client. They're telling me that they're going to get everything. Well, in my opinion, their attorney is doing a disservice to them. Because if they think they know what's going to happen and you're going to win your case, then they're going to have a very difficult time going through mediation. We're going to have a difficult time going through mediation because they're not being told the truth. And then we're going to go to trial, and they're going to be so pissed at their lawyer, which happens almost every time. We go into court, our clients are ready, they have reasonable idea about it, and the other side is for the first time hearing that they're not going to get full custody. I mean, I see it all the time. Makes it very difficult, but I promise you the pain that we get on the up front is worth the pain, the lack of pain that they're going to have when they go into trial. And it makes our trial so much easier because we have done a good opinion letter. They know what's going to come on. When our clients, I don't know about you guys, but I am guessing that this is what happens all the time. You see it when you're walking in with other attorneys, and now as you're doing your own cases, you're going to see this even more, is our clients immediately accept our settlement offer. We go back, we hear it from the judge, we go back to our clients, and our clients are like, yeah, okay, that's fine. And then we're dealing with it with the pain on the other side because we already, and of course, spoiler alert, we've already got our consent order that's about to come up next. But it's not that we're not having the first time we're having a conversation with our clients about that. And so we're having a much easier time with it. And the judges start to see that and they're like us because of that. So like your clients were ready and understood what was going to happen going into this thing. And because of that, it looks like we settle our cases sometimes a little bit more than what it is. Now, I don't know why I tend to be in trial, because once I pick and tell them what the opinion is, I'm not going to back down from it. I tend to be like, okay, well, here's where it's going to be. I'm not going to go down lower than that. So I end up in a lot of trials, but I don't mind them because my clients have a realistic expectation of that. And it starts with this. And then finally, do a fee estimate of the case. And this one's tough because I personally think if it's Buncombe County, it probably needs to look like 20,000. If it's Hendersonville, it probably needs to look close to 20,000. They need to see that in an opinion letter. They need to know that, hey, this is going to cost them a little bit more than what they think. There's some attorneys in Shelby that you're going to deal with that I think do a pretty good job of that. I think that, like, if they go to Becky Brown or something like that she's going to tell them it's going to be $20,000 or whatever it's going to be. And you've got good counsel on the other side that's telling them the same thing. But it may be the first time they're really hearing that. They knew that you've told them until you're blue in the face. The retainer is just at that gets us started. We're working on it, but it's going to be tough. So opinion letter is a good chance to throw that in. And I like to occasionally just put in like 60,000 and just tell them, like, an expert's going to cost you $15,000 because of your business. Really throw it in because I want them to think like, oh my gosh, I wasn't thinking it's going to cost that kind of money. I may need to settle. And that's, so it's not a bad thing on it overall. And when they don't blink, when you give them a $50,000 opinion letter, then hey, I got some room to be able to do a good trial on this thing. So it makes you feel better about it. You've got it in place. You've locked in. And I will just note here, a big case, I will do multiple opinion letters to the client because it will change as you go. So this is a great one. And opinion letters are usually my second tab in my trial notebook, because I like to be able to be like, oh, here's my fact. It reminds me, like, where does that kid go to school? Because the judges love to ask questions like that. Like, well, what school do they go to? And I'm like, I've been preparing for this thing for a week and I don't know. I don't know where Lincoln County even is on a map. If you want to press me, Judge, I think they go to West Lincoln Elementary. It's nice when you flip over to your opinion letter and it's got that kind of stuff in it. So, just it's good to have. It's good to have handy. Okay, so that's opinion letters. The flip side of the coin I was talking about is the trial brief. The trial brief, because this is something law school really trained you for, and that is to take your client's case and make it as good as, like, the opinion letter pulls it down. The trial brief is the exact same thing, but it pushes it up. And of course, it's a brief, so you don't have to have the, necessarily the things, but you still want the facts, the law, application and conclusion, right? IRAC. That's what that's what you were taught in law school. This is the best case scenario. This is you are asking for Judge Scott in Buncombe, who's probably going to get 50-50. This is your chance to say, this is why it's not 50-50. It ought to be a higher to my client, and this is why. And that way, your client's going to see the trial brief too. And trial brief, you don't really get taught in law school trial brief. Your briefs are supposed to be about something, right? It's supposed to be like, oh, my brief is on jurisdiction in this case. That is not a trial brief. That's a different brief. May have the same facts, should have the same facts, but the trial brief is the overall case. So basically, what I would like to say is, if you didn't have a trial at all, you could hand this to the judge and the judge could make a decision based on the trial brief on all the different points, and it should be broken out. This is being a damn good lawyer. You want to be a family law specialist, you do a trial brief, you do this, and you're going to be like, my God, they know their stuff. And you're not going to be freaked out when it comes to trial. You're going to be like, you may feel like, I can't believe I'm having to try this case, but you are going to feel like the best lawyer in the room when you have these two things. So That is the opinion letter and trial brief. I do believe that once you have those drafted, you should have a meeting with the client. We call that the attorney meeting. So, you don't necessarily have to have that in hand at the time, but I think it's better when you do, and you have you have your trial brief and opinion letter in your hand, and you make an appointment with the client, and you just say like, yeah, this is my opinion on it. Do you have any questions? It can be a pretty easy meeting. Hopefully it's a chance for them to amend it and be like, oh, I didn't tell you this, but I moved since then. Okay. Where'd you move? Well, I moved to Tennessee. Okay, well, okay, take that opinion letter and rip it up. But again, you're having those discussions on it as you go. They may be giving you some pushback on stuff. Completely fine. And this is you being a professional. Be like, oh, you think it's going to cost less? Okay, tell me why. Well, what you're saying? Are you saying that they're going to agree to that? Well, no. That's why I'm giving you the opinion letter. It is. And it's a very easy to just a way to, you let your words be bad cop and you can be good cop, if that makes sense. Because, if somebody has to question later what happened, your words are going in these documents are going to be what matters. It's fine to be like, well, I appreciate that opinion, and maybe I'm wrong on this, but I'm going to stand by my letter that this is, it's not like I'm 100% sure this is what the conclusion is, but I think it's more likely than not that this is what is going to be the outcome. And you've advised them. It's in the portal. It's in, multiple places. Okay. Any questions about those two things? Okay. I'm going to close this one out.